Rock and roll. You want me to do the opening? You want me to do the opening?
Open? Try?
No, you want me to do the opening?
Oh,
Hello,
opening.
Viewers.
I'll do the opening, yeah.
No,
You want
of
to do the
course.
opening?
No, I'm kidding, Joe. Do it. I'm not.
Yeah. Hello viewers, welcome to our program on Immigration and You. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, my partner.
Thanks so much, Michael.
Now just to remind you that this is about the time that you should seriously consider filing of H-1 petition if you are waiting for that, and David is going to give you more information about the H-1B filings and how you should be prepared. And I'll make some comments after David give the basic information. David?
Perfect. So, Michael, I'm sure that many of our viewers are aware that we're coming into H-1B season, and actually H-1B season for us begins on January 1st when we start getting inundated with phone calls from beneficiaries, individuals who possess the equivalents of a U.S. baccalaureate degree, or individuals who are in school.
This is the time we start getting calls from the employers and the employees.
Employers, sure.
That want to do H-1. It's a good idea because this needs preparation, you know. If somebody comes on 31st of March, I mean, it's really pushing very hard.
That's right.
And also taking a risk. Because remember, the filing can only start April 1st.
That's right.
And the job can only start October 1st.
That's right. It's never too early to start planning for the H-1B,
exactly.
Because what we can do is we know that the labor condition application that you file online can be filed prior to the April 1st, and what we can do...
And should be filed, not only can be.
Yeah, and should be filed before, so that we're ready to go with the H-1B, so that it's filed on April 1st, requesting the October 1st start date. Now, I'd like to remind our viewers that there are 65,000 H-1Bs available. I know that sounds like a large number, but they do sometimes go fast. In 2008, 3 H-1Bs were submitted for each one slot, H-1B slot, and we ended up in a situation where there was a lottery that was held. I don't know that that's happened since 2008, but the problem is that we can't predict it now. President Obama is saying that we're on the road to recovery. The economy is getting better. Last year, the H-1Bs went relatively quickly. I believe that there were H-1Bs around until June. And
but don't forget, David, remember, there was a time all H-1Bs were gone April 2nd.
That's right. That's exactly what I'm saying. That's exactly right.
So then, of course, slowdown was there. So after that, the next year was probably up to July or, you know. So
that's exactly right.
Now it's picking up again, which means it could go faster.
That's right. And there's no way for us to really predict other than to say that, we recommend to our clients, to potential clients, the best thing to do is to start to plan as early as possible. Now, one of the things that we try to bring to the attention of the H-1B employers is that they have to understand that it's not such a great idea to go to the beneficiaries, the H-1B employees, and say, go out, find your own lawyer to do the case, because the problem, unfortunately, with that is going to be that there are a lot of Department of Labor issues, things that are nuances associated with the H-1B that are Department of Labor issues that affect the employer. So what are those types of things? For example, after the LCA, the labor condition application, is filed with the Department of Labor, the employer is required to post the LCA, which is not difficult to do, but then the employer is also required to have what's called a public access file. And so that public access file contains about 5 or 6 different documents, and they have to have that on their premises the day after they file the LCA. So it's important for employers to know that they have responsibilities in the H-1B process, which are associated with the federally mandated prevailing wage, the public access file, and making sure that they do the things that they need to do with the H-1B employees. So that's one of the nuances in the H-1B process. Also, I want to just mention that there are 20,000 H-1Bs available on a fiscal year basis. Fiscal year running from September 1st to October 30th each year, and from So what you need to do is you need to know that there are 20,000 available for a master's degree, individuals who have U.S. master's degree. So if you're a foreign student in the United States and you're in your OPT and you're still work authorized, it's a great idea to file your H-1B. Maybe you want to premium process it. Do it while you're work authorized on your OPT, because if you do that, then what will happen is that if you have an approved H-1B, your work authorization will continue from the time that you run out of OPT work authorization up through October 1st when your H-1B takes over. So just that's the infamous cap gap that I'm referring to.
Lot of issues that go with H-1B,
That's right.
I can say that it is important for us maybe to, in the future, do a whole, we have done it few times, all the issues that come in H-1Bs, LCAs, wages, transfers, amendments, everything.
Absolutely.
But right now, one important subject today we must cover is the provisional waivers for the 9B, the 3-10-year bar, that the new policy.
That's right, and the new regulation was promulgated, as I mentioned before on one of the earlier programs, on January 3rd, and it becomes effective on March 4th. What I would like to just tell everyone to do is I recommend that if you go online on the computer and look up H-1B season, you'll see that we've written an article about the H-1B season being in full swing, and it discusses in more detail some of the nuances associated with the H-1B. But feel free, if you have any questions about H-1Bs, feel free to email those to us at our email address below.
Now, before go into more details of the provisional waivers, let me say a couple of words. That what has been a situation prior to this memo is like this. You are in this country illegally, right? Even if you get married to a U.S. citizen, if you entered without a visa and you are married to a U.S. citizen, children, a lot of people think marrying a citizen I can apply immediately, but the law doesn't permit adjustment of status. So that person has to go to India to apply. You can still apply there, but not here, but there. However, if he has stayed here illegally more than a year, there are 10-year bar. So what used to happen, this person, petition is filed, petition is approved, National Visa Center, all work is done, he goes for interview, the American consul says, oh, everything's fine, I believe you, you got a children, a wife, no problem.
The visa interview is scheduled at the U.S. consulate abroad.
But listen, I cannot issue you a visa for 10 years because you stayed 1 year, illegally more than a year.
Right.
However, you can apply for a waiver based upon extreme hardship to your wife.
Right, and that application was made at the U.S. consulate abroad.
Actually, there is an immigration office in the American embassy that decides, but consul will interview, take the papers and forward to them.
Correct.
But the whole process was taking more than a year.
Very cumbersome.
Number one. Number two, there was no guarantee that the waiver is going to be approved.
That's correct.
So if a lot of people were not willing to take a risk.
Right. Well, our clients were asking us,
they'll ask me, oh, I will do that.
Can you guarantee that I'm going to be able to get back in and when?
Yeah, then exactly. I will go to India, otherwise not. I cannot guarantee.
That's right.
Right? So they said, there I don't want to take a risk, be stuck there for 10 years and my wife is here.
That's right.
So now, to solve that problem, so that there is no long-term separation of the families and uncertainties, they introduced this memorandum that David is just going to explain.
Well, it's a regulation, and the regulation was promulgated on January 3rd.
Immigration, sir.
Right.
No, but again, one more word on the regulation.
Yeah.
People calling me, lot of people on this.
Yeah.
There is a change in the law. Can amnesty? It's not amnesty. This is just provisional waiver, and it's a regulation.
Right.
Law can be changed only by the Congress. Regulation can be made administrative.
Right, and the regulation is promulgated by the U.S. Department of Homeland Security, and it has gone through, just so everybody understands the history of this new law or new regulation, is that it was something that came out back in January of 2012. In April of 2012, we had a proposed regulation. About 4,000 comments were received in connection with that proposed regulation, which is really a tremendous number.
So, okay, David.
And then what happens is the final regulation came down on January 3rd, and what it says now is that it's kind of like know before you go. What you'll do is you'll have an opportunity to apply on an I-601A form for a waiver, and you'll know whether or not you have an approval before you leave. Now, this is not for everyone. It's for individuals who only are barred because or inadmissible as a result of Section 212A9 sub 1 and 2, which is the 3 and 10 year bar inadmissibility. So if
and the petition is based upon immediate relative, not for other categories.
That's correct. It has to be an immediate
relative. If a person is married to a U.S. citizen,
correct,
or a parent of a U.S. citizen, or a child of a citizen. So here's my question to you.
Yes.
My name is Mr. Patel.
Okay.
I came to U.S. from Canada by crossing the border.
Okay.
And I'm getting married to an American citizen.
Okay.
Lady, nice lady.
Right.
Very pretty.
Okay.
And
Okay.
I am going to ask you to get me a green card here.
Okay.
And you are going to say, I am not eligible, so I have to go to India, and you are telling me this provisional waiver thing.
Well, the first and most important thing I would do is I would say the one thing we want to do is take a look at the new regulation and make sure that, of course, and since you're not married, we don't have to worry about this, but there is a timing issue
No,
in
I'm
here.
a Mr. Patel. I'm getting married to U.S. citizen.
Right, of course, but I'm saying there is a timing issue in here and that we have to make sure that everything happens after March 4th. Okay, because if you scheduled your interview with the U.S. consulate before March 4th, you can't use this provisional waiver.
So I'm Mr. Patel asking you, what shall I do, Mr. Nachman?
Okay, so you're going to get married after March 4th, and we're going to file the papers, and we're going to have the visa the consulate, the U.S. consulate notified after March 4th. So you're going to be okay.
So definitely, when I go to India and go for interview, the consul will give me an immigrant visa?
Well, no, the consul is likely to ask you some questions, and Mr.
You
Patel,
approved, Mr. Nachman, he's going to say 10-year bar, I'm going to give him the approval of the waiver. Why you would not give me?
Well, the problem might be that the U.S. consular officer may delve into the way in which you entered the United States and may find fraud or misrepresentation.
Oh my
God! And if they do that, then that mitigates against the ability for the consulate for the USCIS to have granted you that I-601A. So even though you knew before you left, maybe that issue of fraud was not particularly dealt with. So that might come up at the U.S. consulate, and if it does, then they do have the ability to deny.
Me?
That's correct.
Are you saying then I have to apply for a waiver again?
That's correct. And then
But
the
can
methodology.
you file for me while I am there in India? How long? Within 2-3 weeks or what?
Well, no, unfortunately, the problem is you're going to go back into the quote-unquote traditional waiver methodology, and you'll have to apply for an I-601, and that could take many months, if not years. So that could take a long, long time, Mr. Patel.
Oh my God. But still there's a risk.
So there is still a risk to you.
But listen, they already approved my waiver. So if I file a new one based upon, let us say, some other reason you are saying, right? For example, fraud or misrepresentation, then still they can deny?
Well, you won't qualify to file the I-601A if there was fraud or misrepresentation alleged anyway. So that's not a basis for using the provisional waiver rules.
No, but exceptional hardship, they are saying. I believe that I was told by another lawyer that I have to prove exceptional hardship. Or when you applied for a provisional waiver for me, you put in an exceptional harder evidence.
Right, we'll make an argument, the best possible argument we can, that there is exceptional hardship based upon the fact that you are financially supporting your family members, or based upon the fact that if you are made to leave, unfortunately, your spouse won't be able to cope. And
so
we may have a psychological report to that effect.
You will prepare me fully, right? And most likely I'll get a second waiver also.
We'll prepare you fully, and we hope that obviously things will go as well as they can possibly go. But unfortunately, we can't guarantee a result, because anyone who is guaranteeing you a result is not telling you the truth.
Thank you very much, Mr. David Nachman. I am back, Michael Fulwani again. And I thank you very much, David, for being on the program. And thank all of you for watching this program. I hope that you found this amusing.
It was a great role play.
And if you have any questions about this or anything else, don't hesitate. Send us an email, call us, and we'll try to help you in whichever way we can. Thank you very much, and goodbye.